Hey everyone, welcome to another podcast, and we are honored again to have Lory, a former judge at the Board of Immigration Appeals. And today we're going to continue talking about the categorical approach, which is the way we analyze statutes when somebody is accused of having committed a deportable offense. It's really the art of navigating criminal and immigration law and seeing if the statute of conviction, if you were convicted in New York or Florida, etc., is the equivalent of the federal statute that will cause you to be deported. And it's always our argument that it's overbroad. It's more broad than the federal statute. But anyway, we're going to get into it. Lory, how are you today?
I'm good. Thanks, Felipe. It's good to be back here. And I was just telling you that I really believe that you can never get enough of the categorical approach, and that it shouldn't be as difficult as we sometimes feel that it is. But even the courts can't get it straight in terms of how they're looking at the different elements that have to be taken into consideration. I kind of like to start, for me, and maybe I'm emphasizing this too much, but I like to start with the principle that when you're looking to see whether an individual has a conviction that is going to render them deportable under the immigration statute, we have to look at what was the person convicted of and not what they did. And so that is, I feel like that's the mantra. It's not what they did, it's the crime of which they were convicted. And the problem with that is that there's always a tendency in both fora, actually, the tendency to, in the criminal context, there's a possibility of if you're entering a plea, that the judge will say to the attorney, the defense counsel, what is the factual basis for this plea? And then oftentimes the defendant will, the attorney will give the factual basis of what happened and will then ask the defendant, and do you agree with that? And the defendant will say yes. And if that part of the record gets exposed during the immigration proceedings, we find that the individual may have, in fact, indicated what they did, not what they were convicted of. And in a case where there's a divisible statute, which we'll talk about today, that often can kind of be problematic in terms of them being found to be deportable in terms of the generic offense under federal law.
So, Laura, you brought up a very complicated but important to understand exception to the categorical approach, which we'll be talking about, which is usually referred to as the modified categorical approach, where you look if a statute is divisible, and Lory will explain what that means. And so it's the tendency of the judge, of the immigration judge usually, and definitely the immigration prosecutor, they will do everything they can to be able to use the underlying record against the client. But as Lory has explained, usually the best defense is the categorical approach needs to be applied in a strict manner. In other words, like Lory said in previous videos, we look at the statute of conviction. We look at the statute, the language of the statute, and we argue that you should not be able to go beyond the language of that statute because the person has already been convicted. They've already served their time. They've already paid their debt to society. And now the only purpose of this hearing is to determine whether or not it's removable. And we argue strict application of the categorical approach, but there's always exceptions just to make it fun.
Right. That's it, Felipe. That's correct. So, yeah, a good example of that is, let me see if I can use this actual case that the board just decided.
Beautiful.
Recently the board has addressed two precedent decisions addressing the categorical approach. And the first one, they came out very close together. The first one that came out is called Matter of Cancios Mancio, CANCINOS-MANCIO. And if the listeners want to look it up, you can find it at 28 INN decision. That's the Board of Immigration Appeals decisions, page 708. that was just issued in the last month or so.
Hot off the press.
Yeah, and it's a modified categorical approach case. Okay, and the holding of the case is really something that is nothing. It's nothing new. It basically, the holding is an immigration judge may consider the transcript of a plea colloquy in determining the factual basis of a plea. Now, I have somewhat of a problem with the way that's articulated, and we'll talk about that a little bit, because I believe that, like we just said a moment ago, it's not what the person did, so it's not really the factual basis. It's the elements that the categorical approach is looking at. You're trying to match elements of a state conviction statute with the elements in a federal generic definition of the particular offense. Like, take burglary is a great example. And in fact, this particular case is not a burglary case, but it's the next one will be. But this one is aggravated assault. And it is.
Lory, can I interrupt you? Can you explain why burglary is a good example again?
Okay.
Yeah.
Burglary is a good example for a number of reasons. Number one, the Supreme Court, in a case called the Taylor case, used burglary as an example to explain what a generic definition is and how a state offense needs to be compared to the generic definition in terms of, do the elements of burglary under state law match up to the elements of burglary in the federal definition? And so in the federal definition for burglary, the Supreme Court looked to various sources to determine, okay, what is the generic federal definition? And they concluded that it was the entry into a building or structure with the intent to commit an offense inside that building and structure. Okay? Now, it's really, you were saying originally, we were talking about how the state statutes are often broader than the federal definition. And that's really
okay. So in this case, how?
Okay, I'm going to tell you. So here's the thing: some state statutes are written; they're not written in exactly the terms I said, which would be the elements of entry into a building or structure with the intent to commit a crime therein. So in some of the state statutes, for example, it might be, the statute might read, entry onto a boat, a motorcycle, a car, or a building with intent to commit a felony or a crime therein. Now, that sounds a lot like the federal definition we just discussed, but it's more than a building. The offense could take place on a boat, or it could take place in an automobile. If somebody was, say, burglarizing a tape deck out of a car, that could be burglary under state law, but it wouldn't be burglary under federal law because it's not criminal building or structure. A car would not qualify as a structure. When we're talking about structure, we're talking about a garage, maybe, that sort of thing. So it's really important that we compare the elements of the state statute to the elements of the federal statute or federal definition. And where the federal definition is narrower than the state allows for purposes of conviction and prosecution, then in those cases, it's possible that categorically the offense committed under state law is not a categorical match to the federal definition.
Okay, Lory, so if I get convicted for a state statute that penalizes burglary for entering into a building or a structure, including a car or a boat, etc., that might not be a removable offense, even though it's burglary under the state law.
Right. And remember, what's important here is, again, it's not what the person actually did. Maybe what the person actually did is they did enter into a building, but they could have also entered onto a boat or into a car. So it's not what the person did. It's not the facts, which is why I had some problem with the holding in the board precedent we'll get back to talking about. But it's the elements of the offense. So the elements in the case of burglary that we're looking for are entry, building, structure, and an intent to commit a crime. It's not boat and it's not car.
Right.
Those elements just aren't there. And if those elements are in the state statute, whether or not that's what the person was doing, it's overbroad and it's too broad to categorically qualify as a burglary. And so, in other words, we have to keep it's kind of a difficult mental exercise, because if we know that the person actually went into a building, say a residence or a home, and that's a building, and that's what the person actually did, the fact that he could have done it on a boat seems like, well, what's the point? We know what he really did, but that's not the way we analyze these cases. And it's kind of hard. It's hard for immigration judges, and it's difficult. It's also difficult for respondents in immigration proceedings. You know, there have been some cases where the judge has the person come up on the witness stand, the respondent comes on the witness stand, and he says, "Judge, I went into, my parents' house and I stole their money. And so, yeah, I did commit burglary." Okay, but the judge doesn't want to listen to that. The judge does not want to take that into account. What matters is in the record of conviction. And so that's what we're talking about when we talk about record of conviction. That comes up when the offense is divisible.
Okay. And yeah, what is that? That's important.
Okay, so a divisible offense is one in which the statute that we're looking at, the statute of conviction, contains conduct that a person could be convicted of, conduct that is a match to the generic definition, but it also covers conduct that is not a match. So when you have a divisible statute, the question is, well, which one of these options does the conviction come under?
Can I give you an example that popped in my head, and you tell me if this is applicable? Okay.
Yeah.
Let's say you're convicted of possession of a weapon, and the government wants to try to deport you for the firearm. I think it's 237A2E, I believe. They want to get you under the firearm offense. So the statute says a person is guilty of possession of a weapon when they possess A, ninja star, B, a knife, C, a gun, D, nunchucks. Right? Does this statute kind of create some of the challenges we're talking about here?
Sure, because what we're seeing here is that if the deportable offense is for conviction of possessing a firearm, the statute that you just described, I don't even know if it mentioned firearms. You mentioned nunchucks.
A gun was the third option, I believe.
Oh, okay. A gun is an option. Okay. But it's only one of, say, 4 or more options there. And so, once again, what was the individual defendant convicted of? And we're not interested in what really happened or what he or she really did. So the challenge here, when you have there's a number of options in this statute that you described. It could be a conviction of a gun, which might qualify as a firearm, but it could also be a conviction of any of these other apparatus. And nunchucks always makes me laugh, but that's definitely not a firearm. So when you have a situation like that, if the divisible statute is where one or more of the options that's articulated in that statute would not constitute categorically the crime or the type of crime, firearm offense, that is being described in the federal deportability ground, let's say. So what we have in that situation is we have to look at the record of conviction. In other words, the record can help narrow it down, but the individual's testimony in immigration proceedings cannot be used to narrow it down. That's why if the person's on the stand and they admit, oh, it was a, Glock, it was a firearm, in fact, yes, I took it and I used it in this case. Well, in that case, we know what really happened, but that's not necessarily what the person was convicted of. Okay, because if they were convicted, let's say they were convicted under this general weapons statute that you just described before, Felipe, maybe it might be enough to convict that person to say the individual was found to possess a weapon as described in statute number 1234. That doesn't tell us which of those forms of weapons was the one used by the defendant. So we can't tell from looking at the record what the person was convicted of. In that particular,
when we talk about the record, Lory, what are we limited as to?
Okay. The record of conviction is generally a charge document or an indictment. So sometimes an indictment is used, and sometimes the authorities simply, issue an information asserting what this person is being charged with. That counts as part of the record. And so does a plea of not guilty or guilty, which would, depending on the details of that plea, like the person might say, I'm pleading guilty to violation of the weapons statute. If that's all that the person says in entering their plea before the criminal court, that's also not enough to tell us, right? And this is really important if you're a defense counsel or if you're working with criminal defense counsel, because you want to be as vague as the criminal justice system allows. Now, I'm not suggesting here by saying this that people seek to avoid being accountable for their guilty acts, or if they're being prosecuted for something. All I'm saying is what they need to do is cooperate with the criminal prosecutor to the extent that the prosecution can move forward. But they're not obligated to say, here, this is what I did, and by the way, I can also be deported for this. So when they get to the immigration court and they're in a removal proceeding, if the record from the criminal justice system is vague and it doesn't say, okay, which weapon are we talking about here? Was it a firearm or not? It doesn't have to provide that information. It really, according to my view of what is fair and what would be the intention of Congress in listing certain criminal convictions that a person could be deported for, the purpose is not to retry that individual and say, oh, but we know you really did have a gun and guns are terrible, deport you. Even though that might be desirable, that's not what we're looking for in the immigration context. We're looking for what was the crime in the criminal justice system of which this individual was convicted. And if it's not presented in detail, and if the statute covers more than just the particular offense that would support a deportation order, then the individual may not be subject to deportation.
Okay.
Does that
So,
make
Lory,
sense?
these documents you refer to that we can look at, or the prosecution and judge can look at in immigration court, are these the Shepherd documents that we normally hear about?
Okay, well, Shepherd refers to, yes, the answer to that is yes. And the use calling them the Shepard documents refers again to a case that was a Supreme Court decision. It followed the Taylor case, and in it, which was the burglary case we talked about previously, and in the Shepard case, there was a modified categorical approach used, and it allowed it would include the charging document or the indictment, the plea, if there was, excuse me, a plea colloquy or a plea transcript arising from a discussion with the judge in the criminal court, that would be admissible as part of the record to look at. Now, it's important when we talk about what are parts of the record that can be reviewed, it's important to remember what is not part of the record. And one thing that it's really important to be careful about is that the police report arising from the time the defendant was arrested, the police report is not admissible as part of the record unless it's used in the context of entering the plea before the criminal court. So, for example, if the judge admits the police report into evidence and then says, I'm finding that you were charged with XYZ, and as the police stated, you did these things, factually speaking, if that's admitted into the record, then the police report can be considered. But usually the police report is written up by someone who may not even be there during the criminal prosecution, someone who was just there at the point of arrest. And it may have nothing to do with what the prosecutor actually decided to charge.
Right.
And it also can be very bad in terms of what it appears to include for a defendant. So you don't want the police report to get in there. In other words, you don't want, for example, if we're talking about a weapons violation, you don't want a police report that says, I found a large carton in the defendant's home that had 10 automatic rifles and 5 handguns. That's not part of what the person is convicted of, unless the person was charged and convicted of that. And then that information would appear elsewhere in the record. So be careful about police reports. And oftentimes they're just plainly not accurate at all. The Shepard case articulates what parts of the record can be examined in the context of determining what was the crime of which the respondent was convicted or the defendant was convicted. So that was also, the Shepard documents were more recently discussed in a Supreme Court case called Decamp, spelled Deschamps, Decamp versus United States. And in that decision, the Supreme Court explained that in determining the nature of the offense, it would be permissible also for the prosecutors, either in immigration court or the judge in immigration court or in a sentencing context, it would be permissible to look at jury instructions. If there wasn't a guilty plea, but there was a jury trial, then to figure out what was this person convicted of, again, not what they did, but what they were convicted of, it would be permissible to look at jury instructions. In the Decamp case, and certain circuit courts have also emphasized this point, once again, it's not the facts of what the person did. It's the elements of the offense for which the person was convicted, right? So it's elements, not facts. And actually, that comes up in some of these board cases. In this Cancios-Mencino case, there's the statute under consideration is an Arizona assault statute, which has 3 very distinct descriptions of conduct that the defendant could have engaged in, which would result in a finding of guilty, either due to a plea or due to a trial. And the third of the three is something that just says an accidental touching, that happened, without an intention to harm the person. It's just, I can tell you more specifically what it said, but it's just a very, here, it's called knowingly touching another person with the intent to injure, insult, or provoke such person. So that's way broader than the first two prongs of the Arizona statute, which include intentionally, knowingly, or recklessly causing any physical injury to another person, or intentionally placing the other person in reasonable apprehension of imminent physical injury. When you think about the third prong, knowingly touching a person with the intent to provoke them, okay, you give them a little nudge as you're walking by them, you hit them with your shoulder in the hall as you're walking down the high school hall to your locker or something.
Yeah,
that is not an aggravated assault, but it could provoke somebody for sure, right? Right. And so the question here, in looking at, in this case, Cancios Mancino, what the Board of Immigration Appeals is saying in this precedent is they're saying the transcript in the case that did express the fact that the individual had done more than just touch someone to provoke them. It showed an intentional knowingly or recklessly causing physical injury or intentionally putting another person at risk of physical injury. That transcript is permissible as part of the record to look at. And the reason for that, which is important, is because not only did the attorney in the criminal case describe the conduct of the defendant, which included more of these intentional harmful acts, but also the defendant agreed in the context of, in the transcript, it shows that the defendant was asked, is that correct? Did you do these things, right? And the defendant says yes. So there's that assent from the defendant that was before the criminal court judge. And the board says in a case like that, that it certainly is clear that it was not the third possibility under the Arizona statute.
Right.
And so it's a divisible offense, but in this case, the transcript reveals which one of the prongs the defendant was convicted under. So that's that case. Now, my problem with this case, and I have to say, nobody else agrees with me about this. My problem with this case, though, and I would just caution people to be aware of this, is that what the judge in this case had asked defense counsel, what is the factual basis for the plea? And oftentimes, criminal court judges will ask that. What's the basis for this plea, right? Because they want to make sure that there is some link to the actual elements of the offense. But again, when they ask for that, they're really looking for a connection to the elements of the offense and not just the facts of what the individual person did. I feel like this case comes very close because which the prosecutor replied to the judge and stated the factual basis for the plea, and then the defendant agreed to that was in fact the basis for the plea, comes really close to looking at what the person really did. And much less so, the judge, in other words, the judge was looking to make sure that there was evidence of intentionally placing another person in reasonable apprehension of imminent physical injury or causing physical injury, right? Those are elements. Those are not necessarily facts. So I feel that it's very important to hold the criminal court and also to hold immigration attorneys who will be representing the government in removal cases, to hold them to actually articulating elements and make sure that they're not relying on facts of what the person really did.
So, Lory, in this case, in the criminal defense context, what could criminal defense counsel, either someone who understands immigration law or somebody who hired an immigration consultant who's knowledgeable in immigration law, what could he or she have done at the plea colloquy level in order to reduce immigration exposure?
Okay, well, in this case, because there are 3 categories under this criminal statute, and the third of which we know from looking at it just now would not constitute a crime of violence. What you have to do is think ahead. If you're the criminal defense counsel, you need to know enough about immigration law to know one of these 3 may not actually amount to an aggravated felony crime of violence, which is what the proposed aggravated felony charge would be later on in removal proceedings. So you have to be able to look ahead and say, okay, look to me like if the person is either pleads to the 3rd prong in the Arizona statute or doesn't indicate which of the 3 is the basis for their guilty plea, then they may be home free in terms of later removal proceedings. Now, that's why I said earlier, it's important to be as vague as possible.
Yes.
It's like, what's the line here, Felipe, between how much do you have to cooperate with the criminal prosecution? And if the judge asks you, well, what's the factual basis for this plea? How much can you avoid stating exactly what the person did?
I like the word plea bargaining, and it's called bargaining for a reason. You really can try and get creative and negotiate with the prosecutor. So either be as vague as possible, or the judge is not going to go for it, but you have a DA who, look, you're going to get your conviction. You're going to get whatever punishment is going to be assessed here. That's not going to change. How about we plead to subsection 3, which is the non-deportable one? Would you allow us to plead, even though we know what we did? He's going to get the punishment. Would you allow us, for immigration purposes, to plead to subsection 3? Fine.
Right.
And that would have solved it.
Yes, exactly. And oftentimes the judge will accept that if it's an agreed, a prior agreement, a plea bargain with the prosecutor, and the judge will be satisfied to know that, okay, this is the basis on which I'm going to enter a conviction. Yeah, that's exactly right. And sometimes if you don't have as cooperative a prosecutor as you're describing, and it does happen, keeping it as vague as possible may be all you can do. And then what I would suggest there would be to say, Your Honor, my client's plea of the elements of knowingly touching another person, and leave it at that. Even if the prosecutor hasn't said, yes, you can plead to the 3rd prong, I would just say, leave it to knowingly touching. Don't mention physical injury. And then later on, it may not be all that clear if they're going to try an immigration court to insist that, in fact, the client was convicted of a crime of violence.
So I think this discussion highlights the importance of having immigration counsel, at the very least as a consultant during the criminal trial, during the criminal case, because it does make a world of a difference. This case could have had a different outcome. We would not ever be hearing about it if perhaps there was either more vagueness or more specificity that's beneficial to the client.
Exactly. And this goes back to something that we talked about on an earlier podcast, which was the case in which criminal defense counsel, the counsel, have been held by the Supreme Court to have an obligation to warn their criminal defendant client that they could face absolute removal from the United States, absolute lack of qualification for any form of relief from removal. And so you're right, it is really important to consult with the immigration attorney. I would also hope that the knowledgeable criminal defense counsel, when they see a statute like this, would know, this could be an aggravated felony. I'm not going to let my client plead to this, to number 1 or number 2 outright. So I'm going to have to bargain with the prosecutor, like you said. And, the Padilla versus Kentucky case put that burden on criminal defense counsel. But you're right, to really make sure that there's not a huge mistake made, an unintentional mistake, it's important criminal defense counsel to at least consult with an immigration attorney, if not co-counsel with an immigration attorney. Yeah.
Absolutely. It's our job to protect folks. And so it's really important that you think long-term. If you're a non-citizen and you're being charged with a crime, not only do you have to resolve the criminal proceedings, which are hanging over your head, stressing you out, I understand it, but you have to think long-term. You have to get the help that you need, because it does make a world of a difference. You're going to resolve one problem, but don't let it be a problem in another forum that could separate you from your family. This is a really interesting area. I know you guys can see how much Lory and I love it. There's a lot of nuances, and we're going to continue making these videos so you can keep learning about these nuances, and so we can just have fun in educating people about their rights and about their options.
Yeah, absolutely.
All right, guys. Well, stay tuned. Lory and I will continue bringing you all kinds of goodies and gold nuggets. And until next time, well, see you then. Right, Lory?
Yep. Take care.
All right, everyone. Take care. See you next time. Bye-bye.